welcoming you to How Much Should a Living Trust Cost? I'm Jim Cunningham, and we have Tasha John on here, and this is such a great topic. It's, I think, the first question anybody asks when they think about doing estate planning, because you know what? I think that's the only question many times people know. But we're going to break this down. There are 5 questions you got to look at when in answering the question, how much should a living trust cost? Now, we all know this is really important, and I'm really glad you guys are here today. We got a lot of people watching today's webinar. I will tell you, though, that I've got to give this disclaimer. The information we're providing here today is information. I'm going to share some information. Tasha is going to share some information, but this is not legal advice. So don't take this and go do a bunch of stuff and just say, oh, I saw this video and now I know. But this is something where before you do estate planning, you do need to check with a savvy expert lawyer. If you have questions, there is a Q&A function in Zoom here. So across the bar that's at either the top or the bottom of your screen. So you can use that Q&A. We're going to be doing a couple of polls. And in fact, we can go ahead and start the first poll, which is, do you currently have a living trust? So you can click yes or no. And what we'll do is we have the numbers coming in here. We've got about 46% of the viewers voting. Boy, if only elections went this fast. It looks like we've got people who are voting. And it looks like about 80% of the people, 80% of the people who are watching this have a living trust. So 78 to 22. So the Pareto principle, the old 80-20 principle. So I'm really glad you're here, because what we're also going to talk about is the restatement of a trust and what's involved there. But so let's get started. I do want to cover some traps on pricing. Tasha and I, in preparing for this, discussed this. Many lawyers do estate planning on an hourly basis. And I would say for those lawyers who do estate planning on an hourly basis, that's fine. It's their choice on how they want to bill. But what Tasha and I have found is sometimes, not always, but sometimes the lawyer doesn't know how long it's going to take, doesn't know what's involved, which I would say is could be an indication that the lawyer does not really practice in this area that much. So that would be a red flag if they bill by the hour. Now, the exception is if you're an ultra high net worth person, which is defined as somebody over 10 or $20 million, many times there is an hourly component to estate planning. So for wealthy people, sometimes there's just too much going on and it's an uncertain engagement. So an hourly arrangement can be appropriate. And many lawyers, if you say, gee, I would like an estate plan, right? It involves a living trust. They'll say, here's your living trust. Here you go. And as you'll see, there's a lot of other stuff going on there. A living trust is one part of your estate plan. So like you sit down for a full traditional breakfast, that the living trust is the eggs, but there's bacon and toast and orange juice and all this other stuff that goes with it. So it's not just one thing. There is no form for a living trust. There is a form for a durable power of attorney for property and a durable power of attorney for healthcare. There is a form out there. It's in the probate code. There is no preset form for living trusts. And this is very important to understand. So when people say, oh, I'll just get a form. Well, someone's made that form up. And it's not authorized by statute. So you need to find an attorney who is a savvy expert. Tasha is a savvy expert. Right, Tasha?
Oh, thank you.
Tasha's a savvy expert, and she has an advanced degree in estate planning. I'm a certified specialist in estate planning. We have 7 lawyers in our firm. That's all we do. So we're the experts in our field. You really don't want to go to someone who does criminal law in the morning and a family law or divorce case in the afternoon, and then does your estate plan in the evening. That's not really a good approach. Anything
I do have a story to tell, because sometimes it's helpful when we're looking at traps on pricing. Because I had a client come to me recently that has started their engagement with a different attorney. So actually working with an attorney that practices in this field. However, this is just something to be aware of. Every attorney really charges differently. And this attorney happened to be charging hourly, like we talked about, which we do sometimes with our current clients. Sometimes we update their documents and might charge hourly. Like Jim was talking about with some of our clients of high wealth, we might do that. But in this circumstance, it was the entirely hourly engagement. So first of all, it costs to meet with that attorney. There was a consultation fee. And then from that point forward, the attorney is charging per minute, right? So and attorneys, we'll talk about their charging. Typically, they're around $450 to $600 an hour. And they're charging per minute. And so this client was given just a questionnaire to essentially establish the trust, and it asked basic questions. And one of the questions happened to be, hey, do you want remarriage protection? And this client thought, that sounds kind of nice, sure, and just checked the box and didn't really get advice from the attorney about what that meant or that it would change the entire structure of the trust by checking that box. And when the documents came to the client to review, they wanted an explanation because it looked like a really complicated trust. They weren't sure why there was a division if one of them passed away. Something called the marital trust was built in. And they kept calling the attorney saying, I don't understand, you have to explain this to me. And every minute that attorney was talking to that client, they were being charged just to understand their documents. And went back and forth and really didn't agree with a lot of the things that were placed in there because of that questionnaire. They had checked just certain boxes. And by the end of it all, really unhappy with the representation and with the way the attorney was handling, explaining the documents. Just wanted the client to sign it without an explanation, ended up paying about $3,500 and did not leave with a trust, never signed the documents. So you can see sometimes with not working with the right attorneys in this matter, you have to know what you're paying for. And we'll talk about this. It's not always about price. What are you getting? What's the value you're receiving when you're going through these engagements and choosing the attorneys to work with? So that's just one of many stories that I hear when people come to our office.
Tasha, you're so right. And this really leads us into the five questions we're going to focus on today. Number one, 80% of the people in our poll have already done a revocable living trust. Mm-hmm. Why do so many people do this? We're going to talk about that. What exactly is this? So even though you've done it, you might think, oh, what is this? What's this thing I've signed? Why do I even have it? And then how do you know if it's right for you and your loved ones? And Tasha, that's really, really important. And I think it takes an expert to know if this is really appropriate for you, because in many ways we're kind of like pharmacists, right? We need to make sure and get you the appropriate dosage of medication based on your diagnosis. I guess we're also in that case, the doctors were diagnosing and prescribing. But how do you know if it's right for you and your loved ones? We'll talk about how you find out if it's right for you and your loved ones. And then the big question is, how much is it going to cost me, right? How much money? And then how do you find the right lawyer? Well, that's an easy one. You're looking at two of them. But we're going to talk about all of those as we go through the material. So why do so many people have a revocable living trust? So the bottom line is probate, right? So, and that's at the bottom line there. Many people have found that the living trust is the superior estate planning vehicle in many, many states in the United States. Not all states. California is one of them. If you own a home in California, you're probably going to end up doing some type of, or you be recommended to do a revocable living trust estate plan. So estate planning is, obviously it matters and you can control it. So this is the really, a big takeaway from this today. You're here because this is important. Estate planning is important and you can be 100% in control. Okay. So that's really important. A lot of people that in other parts of the world, they can't leave the property to whomever they want. France has something called usufruct, which is a forced inheritance. So usum fructum, use of the fruits, right? And you're 100% in control. What if you never set up a living trust? What happens? Well, you have probate. And probate, it's been said, is a lawsuit you file against yourself to protect your creditors. Well, actually, you file it against yourself after you die. It's your family that files it against you. Probate. So here's the fundamental difference between a will and a trust. A trust, if it's properly set up, never goes through probate court. A will always goes through probate court because a will is not a valid legal document until the judge issues an order that says it's a valid document. Okay, so a will is just a writing, it's a piece of paper until a judge issues an order. A living trust is is a valid document from the get-go. Probate in California, very expensive. If you own $1 million home, which in many areas is a condo, right? Your probate fees are $50,000. That's even if you have a $950,000 mortgage. So how do you know how do you do all this? Well, what we're going to do is we're going to offer a 15-minute call with an expert, with Tasha. She's an expert in her field. As I mentioned, an advanced degree in estate planning after law school. So she went to law school, and it's a free consult. And that 15 minutes is really designed. This is whether you have an estate plan or don't have an estate plan. If you're looking at changes, it's that 15-minute call. Call Tasha, and in 15 minutes, she can find out if there's any value we can add. And as you'll see as we go through the materials, sometimes we can't really add value. You know, sometimes you don't need to go to an expert, but it takes going to an expert to find out if you need an expert, if that makes sense. So it takes consultation, a brief consultation with an expert, to know if you can get away with going to a non-expert, which is frankly a lower fee that we'll talk about. But many of our clients come to us because they have other needs. So Tasha, I don't know if you want to add anything, what happens in the 15-minute call?
Yeah. Oh, sure. Yeah. In the 15-minute call, we're just going to talk about do you currently have a plan? And it's okay if you do, if you currently have a trust, we're going to talk about that and see if it's appropriate for us to meet and make sure that plan is successful. And at that appointment that we make, then we can go into detail. I can take a look at the documents and be very thorough as to whether or not it's going to be successful. If you don't currently have a plan, I'll just need to touch base on what are your assets? What's the family situation? Because your unique family situation really, really matters. We'll talk a little bit about blended families. If you have a lot of relatives that are not U.S. citizens, if you're not a U.S. citizen, do you have minor children? There's going to be a lot of elements of you and your unique family situation that are going to, I need to know, even in that 15-minute call, to know the basics to figure out what's going to be appropriate for you. So that's what we're going to talk about, because everybody needs a plan. We're kind of talking about, well, do you need an expert to make sure your plan is going to be successful going forward?
So that's the number you call. We're going to show this again. It's super easy. Call and schedule a time and show up, right? Not that big of a deal. We're doing most of our meetings by Zoom now because, nobody wants to go out and take excessive risk with their health. Number two, what is a revocable living trust? Super easy. I'm not going to overcomplicate it. A trust is a bucket. You're the grantor. You're the creator. You come to us. We're the bucket makers. We make this bucket. You're holding on to the handle. You're trustee. You're also called the grantor. Now, those are kind of two technical terms, but the grantor is the person who grants property to the trust, sets it up. The trustee is the person in charge of the trust. A successor trustee is somebody who serves when you're not serving as trustee, if you become incapacitated or pass away, theoretically, or resign. So you create this bucket and you put your stuff in the bucket, but you don't put all your stuff in the bucket. You put your home, your stocks, your bonds, your real estate, your savings accounts, your 529s, right? Those can go in your living trust, right? For your kids, or 529s for your grandkids, but not your IRAs, not your 401ks, your annuities or life insurance. We'll talk about those a little bit later, but those are things that pass by beneficiary designation. So a living trust is a bucket. Putting those assets into the bucket is called funding. This is probably the biggest mistake people make, is not funding their trust adequately. They refinance the house and it comes out. Guess what? You got to do another deed and put it back in. Otherwise, you go into probate court when somebody dies. So it's very important to pay attention to this. So when you pass away, that bucket passes on to your next trustee and they pick up the handle. So instead of you holding all this stuff in your hands and when you pass away, it all falls on the floor, you've got this advantage of a bucket, and the trustee is the person who's holding onto the handle of the bucket, and that's the successor trustee. So Tasha, do you want to talk about Doris and Chris?
Yeah, so this is just a good example of someone that did not have a plan. Doris and Chris come in to meet with us, and they're wondering, are we the type of family that needs to put a plan in order, and do we need a trust? Well, they had the main qualifiers, meaning they owned a home, in the state of California. Even if it was in another state, again, wherever that real property might be situated, they are residents of California. We need to do a trust. They have other assets, though, significant. So they're at that $1 million mark. And they also have minor children. So that's really a huge consideration, making sure you have set up proper documents for the minor children if something was to happen to them. But one of their children is also a child with special needs. So you can see relying on probate as being their plan is one of the worst plans that they can have. I mean, not just for the cost, but really putting their children at a detriment to have somebody else in the court controlling those assets going to a child that is on public benefits or could be on public benefits. So big red flag is if you have loved ones on public benefits, you got to do better planning, and you really need to be working with an expert attorney. So in this situation, we need to create that trust we talked about, retitle their assets into the name of the trust. And then within their trust, we are really taking into consideration their unique family and setting up these continuing trusts for the minor children to inherit within, and their daughter is receiving her inheritance into a special needs trust. It's a fantastic way to maintain those public benefits. We get to say who's in charge of that money. We can talk about care providers. We can talk about all the added benefits we can place into this trust and make some pretty big decisions if something was to happen to them at any point in their lives, but especially when these children are minors. So we can avoid going through the court system and having the court constantly involved in supervising. The importance of naming a guardian, again, it's a nomination, and we do that in a separate document at our firm because we take it, I have minor children, I take it very seriously. And so we want to make sure that whether we're incapacitated, we have some kind of power of putting in a temporary guardian for our children. But also in this situation, making sure that the court's not choosing for them. They have very specific wants, and it could be people closely related to them that they do not want stepping forward as a guardian. And so it's really important in those guardianship nominations to put some reasoning in, because the judge is going to take a look at that nomination and really want to know what your intent was. What do you think would be the best interest of that child? So these become younger families tend to procrastinate and not have a plan. And I have seen some very young families lose both spouses or one spouse recently, and they are really going through a lot right now. So just very important not to procrastinate, put that plan in place. They absolutely have the qualifiers, and any of those additional unique circumstances you can see makes a big difference in who you're working with and how that trust is designed.
Yeah. And I would say that when I've seen people do, Tosh and I have both seen basically really bad estate plans. I've seen estate plans where people write a will and they have minor children. They don't even nominate a guardian. And you typically nominate a guardian in a will. In California, there's actually a form that you can also sign that nominates a guardian. But I've seen attorneys that, are kind of Jacks and Jills of all trades, right? They're doing all kinds of different cases. They may not even think about, right, naming a guardian. Well, for us, that's we're so well trained when we see a client that has a minor child, we know that's an issue. So just another thing. So if you have minor children, or if you're thinking about your kids, maybe who might be doing estate planning, your kids, even though they may have modest assets or not, right? But even if they have modest assets, they really do need to talk to an expert first, because in this case with a special needs child, it can really be detrimental to the family if your plan is not properly set up. Now we have the battle here between trustees. Who are you going to name as trustee? Successor trustees. So I mentioned you the bucket where you've got the hands. And these people are fighting, and they kind of look like siblings, maybe brother, sister, I don't know, husband, wife. But trustees, this is the person who will execute or carry out the terms of your living trust. So after you're gone. Now, some living trusts, more, I would say simple living trusts, say, when we're gone, you collect all the assets, pay all the debts, pay all the expenses, and make an equal distribution between our children. Seems pretty straightforward, seems pretty easy. There's a lot going on there, right? So that trustee becomes 100% personally liable for the debts of the decedent once they become a trustee. So if they say, you know what, mom owed this money to the government and this money on credit cards, I'm just gonna, this is easy, I'm just gonna distribute all the assets. Well, that daughter who becomes trustee now becomes personally liable for those obligations to the government and the credit card. So be very, and she's statutorily prohibited from going to the beneficiaries once there's a distribution. You can't go back to the beneficiaries and get money. There's actually a prohibition on that. So Number three, how do I know if a living trust is right for me and my loved ones? Well, whether you have a living trust or not begins with looking at your assets. If you own real estate in California, the answer is probably yes. It's generally yes. If you own real estate in California, it's probably worth more than, what's the cut? Is it 50,000? I mean, I think there's a special procedure. If it's under 50,000, you can do it by affidavit. You know, who wants to deal with that? Most people, if you own real estate in California, come on, it's worth more than 150,000. If you have less than 150,000 in assets, okay? If you have less than 150,000 in assets, and let me give you an example. Little old lady living in a mobile home who does not own the dirt, the land under the mobile home. Let's say this little old lady lives in this mobile home. It's maybe worth $50,000 and she's got 20,000 in the bank. Guess what? She may not need a living trust. That may not be right for her. But if you take Doris and Chris, if they own a home, maybe they own a home, a modest home, $500,000 in California. It's a pretty modest home. They're going to need a living trust because you got to go through probate to do anything. So you can only know, though, by going to an expert, because there are things that we know and there are things that we know we don't know, but the things that we don't know, the unknown unknowns, as Donald Rumsfeld said, those are the things that get us into trouble. So we have a Q&A, a question here. You said IRAs don't go in the trust, yet you promote IRA trusts. Yes, because IRAs don't go into your living trust. They do not go into your revocable living trust. The IRAs go into an IRA legacy trust, which is a totally different type of irrevocable trust, and we will touch on that briefly.
Right.
So let's talk about inheriting money.
Right.
You want to talk about that, Tasha?
Well, this is one of those things that you might know when an attorney is not going to tell you everything they're thinking when they're speaking with you. But boy, we are running so many thoughts through our head when it comes to trustee choices and where does that person live and are they international and what are the big red flags we see. And this is another one that we are always thinking about when we're meeting with clients and who they're planning to benefit, who's receiving the estate. Whether it's children or family members or friends, we know there's always going to be a risk to inheriting money. 50% of people, they tend to blow their inheritance right away. Maybe they're like these people, spendthrifts. Maybe they're just going to spend it. And maybe we need to protect them. And we've seen some red flags in some documents that we've reviewed where there could just be a clause that says, hey, if they're 18, they just get it all. I don't think 18 is probably the appropriate age, and what age is appropriate? Is it 25? Well, sometimes not. Maybe it's not 25. Maybe we need to kind of lock it up for a longer period of time and talk about each one of those loved ones that's inheriting, and especially what's going on in their life. Because what we also worry about are those third parties. Are they into a lot of creditor and debt? Are they going through a divorce? Do we need to protect them because they have a business they own and it's subject to a lot of liability? Is there something we can do to protect the inheritance? So those outside third party creditors are not going to come after the inheritance. So that is something that we have to discuss and be thinking about. There's a better way to plan. And if you have enough assets that you're worried about that, and at least you've worked hard for what you have, if you want to protect it, this is something that needs to be considered when you're speaking with attorneys. And it's not just, hey, just leave everything to my kids. And that's all that's said. And someone cranks out a form and there it is. Because it might be lost completely when you pass away. And what was that worth?
All right, so we have our next poll, which is, do you want to protect a loved one's inheritance from divorce, bankruptcy, and creditors? So do you want to protect a loved one's inheritance from divorce, bankruptcy, and creditors? So you can click there. We're getting 30%. We're getting 50% of the people voting. I need my reading glasses. I can't see anything anymore.
Still about that 80-20?
83-17. All right, we'll go ahead and end the poll in 5, 4, 3, 2, 1. 83% of people want to protect a loved one's inheritance from divorce, bankruptcy, and creditors, and 17% don't. If you want to protect a loved one's inheritance from divorce, bankruptcy, and creditors, you need to hire an expert lawyer who understands this and really, frankly, a specialist in this. And that would be us. So we're sharing the results there. We have a question. Are such IRA legacy trust must be in my living trust before I die? So the question on IRA trusts, we'll cover this in a little bit. Those IRA trusts are created while you're alive, and it creates a plan, right? It creates a framework or a structure for the inherited IRA. Because something you need to understand with IRAs, if you inherit an IRA, the Supreme Court has ruled 9-0, that there is no creditor protection for inherited money. We have creditor protection for our house. We have a limited homestead exemption. You have a very limited exemption for the cash value on life insurance in California, but you do not have any protection on an IRA, and that is one issue. So if you're part of the 83% of people who wanted to protect a loved one's inheritance and you have an IRA, that's something you should consider, is talking to Tasha or I about the IRA Legacy Trust.
Yeah, I think that's the next slide there too, is that when it comes to most of our clients, that tends to be one of their largest assets that, again, if you're printing out a form and not speaking with an attorney, they're not going to ask you about it, right? They're not going to have any planning for you to even consider are there other benefits? Do we need to protect it? Are you leaving it to someone who's on public benefits? That's a huge red flag. How do we need to protect it? So it's just one of those many assets that's going to require an attorney to go through and make sure you've got the right plan set up for it. And one of those plans for us does happen to be an IRA trust. Doesn't work for everybody, but again, we won't know if that's an option until you actually meet with an attorney to discuss it.
Yeah, and one thing on the IRAs that you need to know, there was a question that, well, is this something that can be set up inside the living trust and then done later? If we were going to write an estate plan that incorporated sufficient provisions to just have your IRA roll into your trust, your living trust would have to be about 180 pages long. And I'm telling you, not a single person on the planet that I've ever met wants a 180-page living trust. Okay, they're long enough as it is. It's fraught with so many problems that are technical in nature that it's best to use a wholly separate plan for those type of assets. So IRAs, if you have IRAs and you want to protect a legacy, you really need to be talking to an expert. And this is why we're doing a 15-minute call. If you call and you say, I'm not the little old lady living in a mobile home with $20,000 in the bank. I've got $1 million IRA. I've got a $2 million house. I've got a business that's $2 million. And I want to protect the legacy for my kids and protect it from divorce. And I don't want my kids to be like the 87% of the people. By the way, 87% of IRA accounts are liquidated immediately after the death of the IRA owner. 87%. That's just a fact. Okay. It's because people don't know any better. All right. In a lot of instances. And sometimes that's the easiest money to get their hands on, because think about it. If you go through a probate or you go through a trust administration, because there's a process you go through, some of the easiest money is the beneficiary designation money. And so many people, they go, man, I've been waiting for this inheritance for a long time. I'm going to go ahead and I don't care if I have to pay $500,000 in tax. I'm going to liquidate that $1 million IRA and put the 500 in my pocket. So that's the free 15-minute. Again, we make it easy. Call that number. And you're going to be getting a follow-up email as well. So, if you'd like to call it right now, you can call it and book a time. Okay. So the big question everyone is probably like asking themselves, well, how much should you pay for a living trust that's best for you? Now, what I've broken down, I've been doing estate planning for 25 years. These are the current range of fees that I see. And it's almost like do you remember the Wizard of Oz, Tasha? I don't know if you've shown that to your kids or not. I loved that as a kid. And I loved that the wizard, the big wizard, he's just this little guy behind a curtain. Mm-hmm. So I'm pulling the curtain back and you guys are looking, and it's not the wizard. It's just a little guy with, ropes and pulleys. So this is what's really going on in the world of estate planning. So pre-printed forms, you can buy those. I wouldn't even bother. You can Google it and probably get it for free. Online or self-help, that $100 to $1,000 price bracket. The danger is, I did hear that the big, who will go nameless, but the big online provider and you see their ads all the time, the big online provider of creating living trusts less than 1% of the people who buy that product actually end up with a completed signed estate plan. So a very low success rate. And frankly, it's too important, and people, I think they kind of freeze up, and you have to make all these decisions with no counseling. So, and some attorneys say what you're getting when you do an estate plan with an expert lawyer is you're getting counseling and the documents are free. You're getting counseling and the documents are free, which is really true, because we don't have people sitting there like secretaries spending hours typing documents. No, we're dealing with titles, and we're dealing with recording recorders, and we're talking to clients, and we're helping people through difficult times. So don't focus so much on the cost of the documents. You really need to look at who you're engaging for the service. So online self-help. Now, non-attorney supervised paralegal. I see a fee range. I've seen some paralegals charge $3,000, which is called the unauthorized practice of law. And the problem with the unauthorized practice of law is it is a violation of the California Business and Professions Code. So there was a big one, again, it'll remain anonymous, that got shut down, and they had done 30,000 estate plans, and they had done them basically all wrong. They just didn't even have good forms, for lack of a better term. Now, those three I would not recommend going to. Lawyers who aren't experts. All right, now there's a little bit of an overlay on fees. Lawyers who are not experts sometimes are okay. So the little old lady with the limited funds and the mobile home, maybe she can get away with not going to an expert. Maybe. I mean, there might be some other issues, like, well, what if she has a stroke and goes to a nursing home? How are you going to pay the $10,000 a month in the nursing home bill? But there are some situations where I don't think the expert needs to do the plan, but the client should seek out an expert to find out if they need an expert. I hope I'm driving this home, because Tasha and I talk with many people that do not become our clients, okay? Because we say, you know what? They can do it a lot cheaper next door or down the street. And this is really not something where we can really add value. Now, lawyers who are experts, this is the fee range that I see, $3,000 to $9,000. Basically, it's about whatever the person bills at per hour. Okay, whatever the lawyer bills at per hour is generally 10 times that amount, because it takes about 10 hours of talking to the people, meeting with them. I mean, you're not getting charged for this webinar, but this is, believe it or not, baked into the fees, right? Because we have to make our time productive. So this is part of it, okay? Now, why is there such a wide range? There's a wide range because we get a wide range of clients. We get a wide range of needs. If a client says, look, I don't care about protecting my kids' inheritance. I just don't. Or I'm leaving it all to the University of California, my alma mater. I'm going to leave it to, I don't know, the dogs, like the dog charities, whatever. Yeah, you might not need the advanced planning. But if you say, man, my son is a serial entrepreneur, and he really needs asset protection. He really needs income tax planning. And my daughter, she's really not good with money, and she's married to a guy that we don't really like, and he's always he's always a money grubber. We need to protect her. Or, I've got $1 million IRA, and I don't want there to be a $500,000 tax bill the moment I die because my kid yanks the money out of the IRA. So these are some examples why it goes higher. But I would say, Tasha, this is probably the range. I would say 90% of the time, this is our fee range. Now, lawyers who charge by the hour, I see the $300. There is an attorney in the Bay Area who charges $1,400 per hour. I am not making that up. He's handling huge estates in Palo Alto, okay? And he's got a tech background. So those are lawyers charging by the hour. When lawyers charge by the hour, we're seeing a fee range of probably $7,500 to $15,000. And this is for higher end estate planning. So, if you have, and I'll give you an example. I have a client who was a very early employee at Google, and he got, I think, 200,000 shares of Google at a very low, like 20 cents, which, I mean, Google's trading at what? Well over $1,000. That's a lot of money. His foundational estate plan was $15,000 because there was a lot going on. He had 50 specific gifts he wanted to make. This is a rich guy. So that foundational plan, that basic sort of, basic probably the wrong word, but that living trust, it depends on your situation. But I'm trying to answer the question, how much is this going to cost me? The more you want to protect for your kids, the more you want to tee things up where you're doing tax planning, the fees are going to be higher, the value is higher, the amount of time we spend on it is higher as well. And our fees generally range from $3,000 to $7,000. Sometimes they're more. Again, I have a client who recently became a client of ours. They've got 30 properties in Lake Tahoe. Well, they're a little bit more, right? Because we're doing 30 deeds. So that is the fees. And if you guys, let's see here, see if we can go to a different poll. I'm going to ask you guys a question. I'm going to launch this poll. Would you like a 15-minute call with a savvy expert lawyer? It will be Tasha. And I'm just launching this poll. This is not a commitment. This is just an expression of interest. If you guys are like, yeah, I mean, I think it's all anonymous. We're not going to tell you. We're not going to be hounding you, but good. So we're getting about 30% of the people voting. And this is if you would like to talk to Tasha, no obligation, 15 minutes. So we'll go ahead and end it. It looks, again, 78% of you said yes, 22% said no. 80-20, the Pareto principle at work, right? So, the way you do that, we'll be sending you a follow-up email after the webinar is over. You can also just call our office, 866-988-3956. So John asks, is your fee estimate $3,000 to $7,000 for the living trust only, or the complete estate plan? It's the complete estate plan. And we'll go over what a complete estate plan involves. But John, thank you for clarifying that. So again, these are the common problems. Oh, this is the biggest one. God, this just drives me nuts. People will come in and they say, well, we did this living trust and it's a form, and I look at it and they don't sign it. I'm like, look, if you don't sign a document, it's not a document. It's just a piece of paper. So we covered unauthorized business law. Oh my gosh, the paralegal, really don't go to the paralegal. And I won't belabor this, but this really can create really serious nightmares for seniors and their families, especially older people, when you go to a paralegal, because as we age, my father-in-law is in assisted living, and his wife of 65 years, I think 67 years, passed away in March. And fortunately, I helped them with their estate plan. So it went off well, but there's so many people that just get in with a paralegal, and it's just, the paralegal doesn't know what the paralegal is doing. The clients, of course, they're relying on a professional. Just a real disaster. So, I will say that attorneys who aren't experts, one of the biggest issues is funding your trust. So many lawyers who are not even some experts, but many lawyers who are not experts, what they will do is they will write up your trust and your will, and they might give you a letter that tells you to transfer assets to your trust, but guess what? It never happens. And so when someone dies, or when both spouses die and the kids come in, they can't handle any property without first going to probate court. Okay. Now they may not have to do a probate, they might, but they still have to go to probate court, which is a big hassle. So cutting corners rarely works. Value, you got to look at price, quality, service. Pick two. You're not going to get low price, high quality, and fast service. There are some people who will give you a lower price and be high quality, but those people, I talked to some attorneys that charge, frankly, less than we do, and they've got a 5, 6, 7 month backlog. They just can't get stuff done. So that's not us. You come to us, we're going to get it done. We're going to have a turnaround, and we're going to complete the job. So it's number 5. How do you find the right lawyer? We have 7 lawyers in our firm, completely 100% dedicated to estate planning and trust administration. So there are 4 of us that do estate planning, and 3 that do nothing but trust administration. And that's what happens after a person passes away. And finding the right lawyer really is the first step. And Tasha, do you want to go over what a complete plan involves?
Right, because it really all has to work together, whether it's the powers and the documents, making sure we're staying out of court. So it's always going to be your trust, a pour over will that says you're leaving everything to the trust, right? It becomes very important if we have to use it. Your durable power of attorney is probably handling some of your financial assets sitting outside your trust. Like we talked about, you've got always something sitting outside. It might be your retirement plans. It could be talking with life insurance providers. And then your healthcare document. So an advanced healthcare directive where you've nominated those people to make those ultimate healthcare choices for you. HIPAA's medical privacy, so release of information. The POLST form is something that we will talk to you about, but we don't complete. It's something you do with your doctor. It stands for Physician's Order for Life-Sustaining Treatment. It is that old DNR form, bright colored front and back, but it is something you would do with your physician. We prepare something that coincides with that called the living will, giving some direction that if all hope was lost for you, it was terminal, that it was okay for them to remove those life-sustaining treatments. Considerations, of course, in all of our documents, especially the trust, we are always thinking about tax laws. We're thinking about Prop 13 and preserving what we can. We're thinking about capital gains taxes. We're thinking about income taxes. And funding the trust is so important. Getting the deed work done, making sure you get to those banks and retitle those assets, and are things pointing in the correct location. And because ultimately, if you have a piece of paper, but you never titled anything into that piece of paper, into the name of the trust, and you pass away, it's just a piece of paper. We're still going full blown to a probate. So, and I can't tell you how many times I've seen that. People think just having something printed out is protecting them, and it's not. And we are still going to court, and how do we take care of them during incapacity? So really need to have the complete plan to take care of you.
Such words of wisdom. We got a question in here. How do you charge for trust administration? That we charge hourly because flat fee doesn't work. So it doesn't, it's not fair to the, first of all, it's not fair to the client. Secondly, not fair to the lawyer. And there are just too many variables, too many different situations. But I will say that on average, because we do track it, on average, the trust administration legal fees are $9,000. So it is more to administer a trust. And I think people are under a false belief. And I talk to other lawyers, and it's the same, by the way. People are under a false belief that, oh, it's really easy. I don't have to deal with any of this stuff. Now, it may be that we only deal with more complex matters. I don't know. Again, this is just like fully transparent with you guys. I'm telling you what, because we track all this stuff. But there is a range. First death, and where there's a surviving spouse, can be less, typically is less. Death of a second spouse typically is more. And by the way, that number includes the ones that go totally like a disaster. Like you've got a jerk brother, you're the trustee, your jerk brother hires a lawyer and just, is not nice to you. All right. So that includes a whole litany of cases. All right. A pour over will. So someone asked, can you say what a pour over will does again? A pour over will says whatever is in my name that does not pass by beneficiary designation, which we're going to talk about it in a moment. Whatever is in my name, which does not pass by beneficiary designation, I leave to my living trust. So at least it goes to the living trust. Sometimes you have to go through a full-blown probate process, which on average is about 16 months. Sometimes it's a single court hearing, and that's a different procedure. Again, only an expert's going to know this stuff. But it depends on the circumstances. That's what a pour over will is. And John asked, you were going to address the trust restatement. Yeah, let me address that trust restatement. And then we got a chat question. Professional fiduciaries, fantastic. So a restatement is a new estate plan. Well, let me back up. Your living trust is a revocable trust, a revocable living trust. What that means is you can revoke it, you can change it. You have to change it the way that the trust says you have to change it, which is typically, kind of obvious stuff. If you want to amend this trust, it must be in a writing that is signed by the people who set the trust up. Okay, so let's say husband and wife, they say, we really need to, we have an old AB trust. We need to get rid of that because that's not good for capital gains taxes. So you go to Tasha, and Tasha says, great, we're going to do what's called a restatement of trust. A restatement is getting rid of your estate plan that you wrote, throwing it out, and replacing it with a new one. Some people are under the mistaken belief, and this is what I term a sunk cost. Some people are under the mistaken belief that, I paid, this thing weighs about 3 pounds. I paid a lot of money for it 8 years ago. Can't you just change a page or two? The problem with that is you're not buying documents. You're buying the legal counseling. You're buying the attorney's knowledge, skill, expertise. You're buying the ability to have us have a staff and get things done. You're not paying for documents. So typically restatements many times are less of a fee because there's no funding. This is like if you have all your assets in your trust. But some, if people come in and we were talking about, there's a famous person who's on TV a lot who sells a living trust kit. And you want to talk about that, Tasha? What do they say to do?
They say, oh, take it to a free consult with any estate planning attorney and then pay them to fund it and figure out what's wrong with it.
Yeah, that's gaming what that is that's gaming the system. That's like putting slugs in a vending machine. You remember slugs that kind of look like an old nickel or quarter? And I suppose you could do that. Not particularly great. Now, restatements. Is a restatement the same as what you paid for your estate plan? Probably, because it's a whole new estate plan. It's a whole new counseling process. We actually go through and pull all your deeds. So that is a restatement. Now, the advantage of a restatement is you keep your existing name of your trust. So my living trust is the Cunningham Trust, dated, I think, March 20th, 1998. I've restated that 3 times because my family situation's changed, right? More kids, moved, tax laws changed, but we keep that same date.
Yeah, and if you're our current client, it's a little bit different versus if you're coming in from another attorney and we're having to restate the trust. You can imagine that our documents that we have created and constantly change over the last 26 years are packed full of a lot of powers, a lot of protection, and it's really important every word that we put into there. So we have to be drafting off of what we know is important. That's why we're restating the entire document.
And then Susan asked for life insurance. If you want to put it in an irrevocable trust, can you put that in the trust later? You can, but there's a 3-year look back on that, basically. So there's a 3-year time period after you transfer it. If you pass away within that 3 years, it's included in your estate. Is there an approximate price for an irrevocable trust? Those are done many times with more complex plans, but I would say if anyone's charging less than $2,500 for an irrevocable trust, they're not putting enough time to get it done right. So I think that would kind of be a minimum. But again, it depends. A lot of times this irrevocable trust is connected with another really important part of your estate plan. And so it's hard to kind of parse them out, but I would say that's kind of the starting. Tasha, I don't know. I think people are.
Well, it depends. If we're talking about Medi-Cal planning or VA planning, you're looking at much higher fees when it comes to that kind of planning and funding and moving money versus it could be a different type of irrevocable trust. But yeah, they're typically, they're very extensive. They're huge time commitments for attorneys. And they tend to be, especially emergency critical Medi-Cal planning, tend to range much, much higher than that. They tend to be more.
Yeah. So I think the question there was putting life insurance in a trust, not would for a traditional life insurance trust to avoid estate taxes. That's one thing. What Tasha's talking about is something we haven't even talked about, which is when my in-laws were living together in the same nursing home, I think it was 12,000, 11,000 and change, almost 12,000 a month. They were going broke in that nursing home. And so we had to do a plan, but those plans, I don't know anyone who does those plans for under 10,000, Tasha.
That's correct. I don't either. Yeah.
They're very, and it takes up a huge amount of time and every single one's different. And you're dealing a lot of times with a disabled person and institutions. And it's just, it's a labor of love, I got to tell you. Who are the 3 attorneys who do administration? That would be Rochelle Lee Warner, Janice Shen, and Liz Seitz. So those are the 3 lawyers. All right. Blended family. Okay, so these are, oh man, we did a whole program on a blended family.
We did, yeah. Just so important to be planning. If it's your second marriage or if you have children from separate marriage, this takes some of my most difficult planning part counseling has to do with blended families. And if you fit into this category, it's just so important to get a proper plan that's going to address every single want and need that you're wanting to provide for the spouse, but also for the kids later down the road. These can be some of the most complicated structures that we create when it comes to planning. And you can see the fees vary because of that. You're looking at a more complex planning and a more complex trust.
Yeah, and then, and you know, especially if you put in a family business, if you put, if people have prenups coming into it, the prenups really kind of put the brakes on the estate planning process, because we have to go through that prenup and make sure that the estate plan doesn't violate the prenup, right? Which sometimes they do, just the nature of them. So you have to be very, very careful. You know, there's for many people, you know, and again, if you have a blended family and you live in a mobile home and you have 20,000 in the bank, maybe it's not that big of a deal, right? But, you know, our clients, what ends up happening is, you know, you've got maybe $1 million, one spouse has $1 million IRA, the other spouse has the house. What happens when one person dies? That's a big, complicated question, okay? So we have some questions. I would appreciate a referral to 3 professional fiduciaries that I can interview for my future needs. That's from Lola. The California has a professional fiduciaries bureau. There are 3 types of fiduciaries: friends and family. All right, these are non-professionals. Then individuals, who are what are called private professional fiduciaries in California, and then you have trust companies and trust banks. A trust bank is Wells Fargo Trust Company. A trust company is Premier Trust in Nevada. They charge different fees, and if you'd like to, that's again part of the counseling process, which is what's right for you. That's something, if you had questions on that, and Lola, I would encourage you to call Tasha and get the names of 3 fiduciaries. And then Wanda asks, how much should you pay for a special needs irrevocable trust? I would say a standalone, and Tasha mentioned a special needs trust for a loved one with special needs integrated into the estate plan, which, by the way, I think on all of our estate plans, Tasha, or most of them, we have what's called standby special needs.
Yeah, we have a backup one.
Okay, we have a backup because a lot of people become disabled later in life and they're on needs-based public assistance benefits. But I think the standalone special needs trust, just that component I'm seeing is, if you just came in and did a standalone special needs trust, I would say $3,500 to $7,500 is the range that I see with practitioners. If you integrate it into part of your estate plan, so if you're doing a living trust plan and a special needs trust, so other family members, right, can leave money to that trust before you die, essentially. You can bundle, you know, the more planning you do, the fees go down because it's the same counseling, the same signing. So our costs as professionals go down, but that's something that we do on an individual basis. But I hope, Wanda, that answered your question. We have another question, maybe a dumb question. Can you prepare a prenup agreement, say 3 years after marriage? Absolutely. That is not a dumb question. That's called a post-nup. There are prenuptial agreements and post-nuptial agreements. That would be a post-nup. Trust protector. I love the trust protector. Tasha came up that she calls it the superhero feature. But a trust protector, if you have a continuing trust, let's say you have this wonderful daughter with special needs and you want to provide for her, and you say, you know what, I want you to have enough money so that, you know, you can be taken care of and not have your public assistance benefits compromised. And I would say the single most important benefit is being a client of the regional center. Yes, the dollar amount per month helps, but being in the social services system is probably the #1 benefit to being, you know, that a special needs trust would bring. But a trust protector is very important, because the trust that we're talking about, once you die, your living trust, your revocable trust, becomes irrevocable. You can't change it. You can't amend it. What if tax laws change? What if probate laws change? What if your loved one with special needs moves from California to Oregon? Guess what? Those are 2 separate legal structures. The trust has to change to preserve public benefits if you go from California to Oregon. That's just a fact. So a trust protector is somebody who has power over the trust and the trustee, but who is not the trustee. And a trust protector, this power exists, by the way, in a court. So even if you have an irrevocable trust, if your circumstances change, you can go to court and modify an irrevocable trust. But with the trust protector, you don't have to go to court. And that's the single biggest benefit of having a trust protector. Now, if you don't have continuing trusts, meaning if you say, when I die, everyone gets their check and they go their separate ways, I'm not sure you need a trust protector. Do you need an expert? I don't know. You can talk to Tasha for 15 minutes and she'll let you know if you need an expert. But if you have a continuing trust, if you have a trust that keeps going on after you're gone, really seriously consider a trust protector. And I mean, there are very few trusts, Tasha, that we write that do not have trust protectors.
Yeah, because it can
That's a
save the
great
day.
feature.
It's kind of that emergency break glass. We need to get this taken care of. And I'm telling you, you will never see this in just a print off form or even from other attorneys. And it's a modern way of estate planning. It can be very valuable. If you never need it, fine. But the day that you need it, you're just going to be so thankful. It's just going to save so much time and money by avoiding going through the court system. And so, yeah, it ends up very rarely do I not put a trust protector into our documents.
And we have a question. Does the fee you charge for a living trust vary depending on which of your attorneys one works with? Because I assume you don't all charge the same hourly fee. I will say if I'm doing it, I'm probably going to charge you more than any other lawyer in it because I spend most of my days mentoring the other lawyers. I do have clients. I tend to handle the higher net worth clients. We were talking about a client today, a $40 million net worth. And that's something that I get involved with, not because Tasha lacks the competence, but if I have a $40 million client, I'm reaching out to Tasha because it's like, this is too important. This is too big. There are too many issues. We need more eyes. And another thing that we do as a firm, every Wednesday at noon, we meet. And every Wednesday, we go over our cases and we put our heads together and attorneys will bring up issues. They'll say, you know, I have this tough issue. You don't get that with a solo attorney. And so it's a lot more fun, frankly, to work in a firm with 6 other peers. All right, tax planning. Well, this is a chance for our last poll. So I'm going to go, actually, I decided not to do that poll. Anyway, Prop 13, if it's important to you, it's probably really, really important to you. We have so many clients, especially near the coast, you know, LA County, Orange County, San Diego County, the Bay Area, you know, even in the Sacramento region. We have so many people that they would have to sell a property if they lost Prop 13. Now, there is movement in the California legislature, and I'm telling you, this is both Republican and Democrat. There is a move afoot to chip away at Prop 13. All right? It's something you need to be aware of. There are ballot initiatives out there that seek to chip away at Prop 13. If you don't care about Prop 13, that's one reason that you may not need an expert. You may need an expert for other things, but this is one thing that I would say, Tasha, 80% of our clients want to keep Prop 13. They might
not know it. They might not know how important it is when they come to see us, but when they're saying, you know, I want to leave this percentage to a grandchild, or I want to make sure this house gets to a grandchild. And then we start telling them that Prop 13 won't apply then. Can your grandchild, you know, be able to afford the new property tax on that? So it might be something that you're like, I don't know if it applies to me. That's okay. I mean, that's something that we're there to advise you on, to make sure that if we have it, we're not blowing it.
Yeah, and I would say, I
Yeah.
would say that estate planning attorneys, because we do trainings for other estate planning attorneys, I would say estate planning attorneys as a community have a limited understanding of Prop 13. This is such a deep, you know, such a deep subject, but and there are attorneys that literally all they do is specialize in Prop 13. Like that's all they do. So there are very few of them. So that's something where we're very well versed in Prop 13. We help people through very, very tough situations. Reducing income and capital gains taxes, that's a no-brainer. I mean, there are a lot of ways that our clients reduce income tax. In fact, we have a webinar tomorrow that we're doing with a CPA who has offices in Northern and Southern California, his kind of a larger firm. We're going to go over why 2020 is so unique. So I'd go to our website, register for that at CunninghamLegal.com. Now, beneficiary designations. So we're going to talk about assets because there are some classes of assets that pass outside of your living trust. Life insurance, IRAs, 401ks, annuities, those pass outside of your trust. Here's the takeaway. You need to pay attention to this, folks. If you have a life insurance company with XYZ life insurance, whatever it is, you might want to pick up the phone or reach out to your agent and just ping them and ask them, hey, if I die, who gets my life insurance? Because I will tell you, it's the beneficiary designation that the institution can find when you die that determines who gets the property, the life insurance, the annuity. It's not what it says in your living trust. It's not what you think. It's not the documents that you hold, but these are documents at the institution that they can find. And we've had very few, but some instances where the institution cannot find the beneficiary designation. So I think that's probably a good thing to do, to reach out to them. Life insurance, I'll just say that our clients typically took life insurance out as an income replacement, maybe to pay off the mortgage, pay education costs, maybe pay for the funeral or any debts. But the clients don't have any of that anymore, right? I put my kids through school. My mortgage is paid off. My debts are paid. I have no debts. I prepaid my funeral. What do I do with my life insurance now? One thing you can do is you can do a tax-deferred exchange into a policy of long-term care insurance. So long-term care insurance, if you have some cash value, you can repurpose that. You can also do it with an annuity, but you can repurpose that and leverage that money. And we're seeing clients put in, $100,000 and immediately get $300,000 worth of coverage on long-term care insurance. And if they never use that money, that $100,000 goes to their heirs or their beneficiaries. So very important. So if that's something you'd like to talk about, have that be part of the topic of the 15-minute conversation. So I happen to be a third-generation pilot. I'm not a current pilot. I'm the only one not to have crashed a plane in my family. My parents are pilots. My mother was an air taxi pilot in Alaska, and her dad was a pilot who started flying in the 20s. So that is not a parachute, guys. That's a backpack full of socks, okay? This is the analogy I'm using. It's like parachuting. Estate planning is like parachuting because we're not getting out of this world alive. We're all going to die, okay? We're not taking our stuff with us. It's staying behind. I want a successful outcome. I want to make sure that my parachute is packed properly with an expert. So that's me, right? And see the expert? I think, Tasha, is that you like guiding the thing there? Maybe that's me.
No way, I'm never doing that.
Okay. Q&A coming up. Is someone going to give you their story in 15 minutes? Can you get closer to the cost? If someone gives you their story in 15 minutes, can you get closer to the cost of a trust? Yes. Yeah.
I can get a little closer. I at least know whether you should be meeting with us or possibly maybe you don't need the kind of plan that, we're going to be creating. But regardless, you'll go forward into a consultation. And during that consultation, when I can really dig into what is specific, what assets are we looking at, what kind of planning we need, certainly by the end of that consultation, you're going to get a firm price and you can choose to go forward or not. But it's, I can give you an estimate. Sometimes I get into those appointments and so many things pop up that are a lot more complicated that it tends to be a different price. So I'll do the best I can in those 15 minutes to give you a good answer.
But it's important, once a fee is quoted, that is the fee for the defined scope of work. And that's the difference between trust administration and planning. With planning, we have far more control. Trust administration is kind of like a pig in a poke. So you don't know what you're getting. 15 minutes are free, but what's the cost of the follow-up consultation? We don't commit to a fee. That's a really good question.
Well, the 15 minutes is typically just a phone call. It might not even take 15 minutes. I just want to talk and make sure you're a good fit for a consultation. If it's for estate planning purposes, the consultation will be free with me to talk about the plan, review the documents, look at your assets. If it's a trust administration, there is going to be a fee for a consultation.
Yeah, because a lot of times with trust administration, not everyone who has a paid consult with trust administration continues on as a client. Mm-hmm. Many times all their questions are answered and there's no need to even do anything beyond that consult, right?
Yeah, there are particular consultations in estate planning that we do charge for. So like a Medi-Cal planning appointment, there will be a fee to meet with me to talk about Medi-Cal planning. Yeah. Okay.
Well, let's give it a few more minutes or a few more seconds. And any more questions? Well, with that, you want to call it a wrap?
All right. Yes. Thank you for joining.
All right. Well, thank you everyone for attending today, and go to our website, CunninghamLegal.com, to see more webinars that we're doing, and also 866-988-3956 to book your time with Tasha. And it was great spending some time with you guys, and have a great day.
All right.